Hey folks, David Stewart here. I hope you guys are having a fantastic day. Let's talk a little bit about intellectual property today. Not just copyright, not just patents, but trademarks and some of the rather interesting and devious things that can happen with trademarks, at least here in the United States. And because it happens here in the United States, you can expect variations of this in other countries, particularly those in Europe. None of this is going to be legal advice or anything like that. This is just an informational video with a couple of examples that illustrate the points that I'm talking about regarding trademarks. So I see a lot of confusion in the comment section between trademarks, patents, and copyright. Most often, people think copyright is something a little bit different than what it is. So let me start by explaining what copyright is in a broad sense. This isn't legal advice. If you have a conflict over what is or isn't copyrighted, or someone thinking that you are violating their copyrights, you should consult an attorney with that area of expertise. It is actually a rather complex area of law. Anyway, so copyright means that you own the creative work that you have created. So if you write a book or write an article or write anything, you own it in a sense. The copyright means you have the right to control all copying of that information. So that means someone has to come up with a legal agreement in order for them to publish it for you or to gain a right to use it in some sort of way. You own the copyright of what you've produced. This includes derivative works. So if you write a piece of fan fiction, you own that piece of fan fiction. Now, as to whether you can publish that derivative work, that's where things get more complicated. But, if you write Harry Potter fan fiction, J.K. Rowling does not own your story. You own your story. Whether or not you can legally publish it, that's a separate discussion. So even for derivative works such as fan fiction, you own the copyright for that. Copyright is something that can expire after a very long time, and then it ends up in the public domain. Copyright is attached to a specific creative work, like a book. Copyright is not attached to things like characters, and here's where we're getting into the area of trademark, okay? What is a trademark? A trademark is a name or even a symbol that is completely bound up with a brand or some other entity and can't be separated from it. As such, that if you were to use that name or that symbol, then a reasonable consumer would be confused as to who they're actually doing business with. Just to give you an example, you can't name your restaurant McDonald's, right? If you named your restaurant McDonald's, what would people think the restaurant is? They would think it is a McDonald's restaurant being franchised or owned by the McDonald's Corporation, serving food that is designed and distributed by McDonald's Corporation. And if you had those golden M arches, those are a trademark. So McDonald's is a trademark. It is associated with the brand of McDonald's and can't be separated from that brand. Now, why would you get sued if you were to make a McDonald's restaurant, even if it was very different from McDonald's? And that's because a consumer might get confused about whether that was an official McDonald's or was a restaurant belonging to someone named McDonald. And this stuff has actually been, panned out in courts of law over long periods of time. I use McDonald's as an example because almost any reasonable consumer in the United States would know what a McDonald's restaurant is, and therefore they would assume if you had the golden arches and named your restaurant McDonald's that you were a McDonald's restaurant. They'd be rather confused if the food was below the quality standards that they expect, and therefore could harm the brand of McDonald's. They'd be like, well, I was at this McDonald's in Phoenix, and it was terrible, and it wasn't a real McDonald's. Well, then you've harmed the McDonald's brand by reducing people's opinion of the McDonald's brand when you shouldn't have been using that name. So yes, can a corporation suffer losses due to trademark violation? In a lot of cases, they can. More than that, it's really about customer confusion. Where this becomes really interesting is that trademark can be almost anything. And in order for it to really be a trademark, you just have to be able to argue it in a court of law that it happens to be a trademark, that it is something associated with the brand. And so I have a really good example here of what I'm talking about. And so I just thought I'd show it to you, which is that Gibson Guitars actually sued successfully. First, they were getting cases dismissed, but they sued again for trademark violation for using these guitar shapes, a V guitar shape, and then this Explorer guitar shape, and I think one other that maybe is shaped like a Les Paul guitar. Now, Dean had been making these guitars for 40 years or something at this point with these exact shapes and the shapes that you see here. So this one is the same shape as a Gibson Explorer, and this one is the same shape as a Gibson V or Flying V. Now the headstocks are different. These are very different from Gibson headstocks. Gibson headstocks tend to just be that big trapezoid thing, and these ones have a nice strong Dean V with the wings here. And Dean has some other guitar body shapes that are quite a bit different from what you would see over at Gibson and are original to the Dean brand. So they're suing, saying that a consumer would be confused about these shapes. So yes, even the shape of a guitar can be trademarked. So this is the other shape of a Dean guitar here too. So this is a Les Paul, and you can look at here's a real Les Paul body, and here's the Dean body. Now these are different in a couple of important ways. The shape of the horn is slightly different. I have a Guild guitar that's basically like a Les Paul, but a little bit bigger, a little bit different horn, but the shape is very indicative of a Les Paul. It's very close or evocative of a Les Paul, let's say. So there's the Dean Explorer. Here's a Gibson Explorer. You can see that they are very similar, including even where the knobs get placed. Different bridge. Dean has a different bridge. So would a reasonable consumer be confused about this? Well, the total damages were like $4,000, which is really nothing in the grand scheme of things. And Dean, I think, has just chosen to keep making these guitars, which is really wild. So I don't know quite what they're going off with there, continuing to make guitars when they've had a result of a legal action say that they're in violation of trademark here. Now, any guitar player would actually not be fooled by this at all. They would not see the Dean here, and they would never think this is a Gibson, either one of these, because they don't say Gibson on them. It's that simple. You look at it and you're like, it's a Dean. It's a Dean because it says Dean. Gibson's a Gibson because it says Gibson. However, there is the possibility that a consumer who has never owned any of these guitars before and doesn't really know anything about guitars could buy the Dean guitar and then realize only later it's not a Gibson. Okay, that is something that could be a possibility. Imagine your wife is going to buy you a guitar. She knows you want this shaped guitar. She goes down to the guitar. Oh, that's the shape of the guitar my husband wants. She buys the guitar and she gives it to you, and you're like, oh, it's a Dean. When you told me you got a guitar, I thought it was maybe getting a Gibson Explorer over here, one of these cool things, Gibson, the classic brand there. So I could see how maybe, an unknowledgeable person, but the bigger point here is that it is possible to trademark a shape. Is this copywritten? No, this is not a copyrighted shape. This is a trademarked shape, apparently. Now, Gibson had never defended this. There are many other brands that use this V, but when you go into a court of law, what really matters is whether, it is bound up with the Gibson brand, and they could make a reasonable argument that it is, and that a consumer could be confused by the use of these shapes. Dean has some shapes that are like this that are a little bit different, a little sharper, and obviously those wouldn't apply to trademark because they don't look like the Gibson shapes. They look a little bit different. Dean makes that classic, the Dimebag Darrell shape with it. It's like a V on the back. It's this on the front, and then it has like a V shape on the back. I always liked that one. I always thought that one was cool. So what does this mean for creative types when it comes to trademark? Well, you can have things that get captured by corporations, trademarks which get captured by corporations. All you really have to prove is that whatever the trademark thing is, it's bound up with the brand. And a consumer would be confused if someone else were to use that trademark for their product. I'll give you an example. People often talk about Mickey Mouse going out of copyright. All that means is that the original Mickey Mouse cartoons will be in the public domain. It doesn't mean Mickey Mouse cartoons made after that will be in the public domain. The Prince and the Pauper starring Mickey Mouse will still be a copywritten work because copyright's attached to the work. It's not attached to all the things related to that work and all the derivatives of that work, of which Prince and the Pauper would be a derivative work maybe many times removed from like Steamboat Willie or whatever the original Mickey Mouse cartoon was. So Steamboat Willie might go into the public domain. Does that mean you can make Mickey Mouse cartoons? Well, I think you would find in a court of law that you could not. And the reason is because Mickey Mouse is himself trademarked. The name Mickey Mouse is a registered trademark. You can actually register your trademarks with the U.S. government. You don't have to register copyright, but you can. You can file things at the Library of Congress to have proof that you created it at a certain date. In case there's a lawsuit, it just says the Library of Congress received that work on that date. That's all that happens to be. But you can register trademarks so people can go look them up and see if, make sure we're not violating anyone's trademarks before we start a business. I think that's probably like good. You could do that with Google now, but the registration service might have been useful 30 or 40 years ago. But yeah, you can't call it a Mickey Mouse cartoon if you make a Mickey Mouse cartoon because Mickey Mouse is a trademark. Not only that, but the shape of Mickey Mouse is trademarked. That can't be separate from the Disney brand. Anyone that sees those mouse ears thinks Disney is involved with it. Anytime there's going to be a Mickey Mouse cartoon, you're going to think Disney is involved with it. So yes, you might be able to, because Steamboat Willie is in the public domain, make a derivative work of Steamboat Willie, but can you mention Mickey Mouse in it? Probably not, because it's a trademark. Could you put that in the title? No. Maybe you could have it in the cartoon. Well, you'd find out when you got it into court, wouldn't you? Could you have a character that looked like Mickey Mouse? Possibly not, because a character that looks like Mickey Mouse might be trademarked. Mickey Mouse has been on so much merchandise. Mickey Mouse is himself trademarked. Not only that, but if you look at a lot of fine print, you'll find that many other things Disney has trademarked, including Wookiee and Droid. That's right. You remember when the phone came out, the Droid phone? Well, they actually had to work out an agreement with LucasArts but Lucasfilm, because the word droid was a trademark of Lucasfilm. Meaning anytime somebody used the word droid, you knew that it was a Star Wars product and that it was associated with Lucasfilm International. So if you were to let's pretend that copyrights expire after 20 years like they did way back when the country started, but you still have trademark laws. Could you make a Star Wars movie? Well, you could make a derivative work of Star Wars, but you couldn't call it Star Wars because that would be confusing to people. Star Wars is bound up and can't be divided from the Disney brand and from the Lucasfilm brand. In other words, if you made a Star Wars fan film, you'd be deceiving people into thinking that they're seeing somehow an official Star Wars movie made by Disney, who officially owns Star Wars, or made by George Lucas if it happened before the Disney stuff. So we could be making our own Star Wars if copyright was back to being 20 years, maybe, but we couldn't call it Star Wars. We also couldn't mention Wookiees because that's a trademark, or Han Solo you find is trademarked, and Luke Skywalker is a trademark. So you'd find that you're still in a pretty gray legal area to make a derivative work of something that goes into the public domain if that is a corporate work. And that's because being a corporate work, those ideas, those characters, those images, just the shape of Mickey Mouse, that is associated from and can't be separated from the brand. And a reasonable consumer would be deceived as to the origin of the work. So, none of this is all like hypothetical stuff, right? And of course, you can leave me your opinions down below about what you think about trademark law and whether you think being able to trademark the shape of a guitar, a classic shape like this, which looks like a single cutaway acoustic guitar just shrunk down, if you should be able to trademark the shape of a guitar, if you should be able to trademark the shape of a cartoon character, if you should be able to trademark something like Wookiee, do you think that's okay? I mean, it is what it is. I know that somebody came out with a Conan the Barbarian comic, but they couldn't call it Conan the Barbarian because Conan the Barbarian is trademarked by a company that manages the Conan the Barbarian brand. You couldn't call it Conan. He had to call it the Cimmerian. Okay? And it wasn't a bad graphic novel as far as things go, but you couldn't call it Conan, even though it was a derivative of a work that had entered the public domain by Robert E. Howard, almost 100 years ago at this point. And the reason is because Conan the Barbarian is a brand, and the consumer would be confused as to whether this was an official Conan comic put out by the Conan the Barbarian group, which licenses it to Marvel, etc. There's a lot of legal gobbledygook. Now, if you could do anything you want to do if you're willing to fight for it in court. If somebody really wanted to make a Conan comic or a Conan book and then fight for it in court, undertake that huge legal process to prove that this company, which has the trademark for Conan, shouldn't actually have a trademark for Conan at all, that's not something you can trademark. Yes, the name Conan. It's associated with the character Conan the Barbarian. Then you can do that, but most people are just not really willing to do that. It's much simpler to do an original work or to just really, in a big way, avoid anything that has to do with trademark. Trademark is something that never expires. So copyright might expire. Trademark never expires. Patents expire. Patents are related to inventions, intellectual property called an invention. They expire. Trademarks never expire. So while the patents for a Ford automobile expire, the word Ford never expires. That is a trademark of the Ford Motor Corporation. You can't call your car a Ford, or people will think it's a Ford made by Ford Motor Company, and you can actually harm the brand by selling them limited cars, right? Fords don't work. Well, it's just this other company selling cars under our name, using our name. So yeah, you can actually damage a brand. It's possible to do that. Remember, brand is like something, it's kind of amorphous. It's like this goodwill that people have towards an idea of a corporation or a company or an entity that makes certain things. And in court, you can prove that it potentially could damage your brand, or you can look at it another way if you want to think just philosophically. McDonald's Corporation spends a lot of money in advertising for its McDonald's restaurants. If you open a McDonald's restaurant without paying them a franchise fee, it's kind of like you're stealing the results of their ad revenue. Like they're advertising your restaurant and you're not paying for that. You're not contributing to that ad. You're not contributing to the ads at all. You're getting like free advertising that someone else paid for with the explicit understanding they'd only be advertising for their stores. So that's another interesting way to look about it, but that's not the legal arguments that I usually see for it. It would be that like a consumer gets confused between this and thinks that they're probably from the same company without knowing anything about Gibson or Dean. Somebody who's not a guitar player, I could actually see them being a little bit confused by these two things. They might be like, those two guitars look exactly the same. I'm like, they look nothing alike. I mean, they look a little bit alike, but they're very different. But, a slightly less knowledgeable consumer, most consumers shopping for guitars are not experts in guitar. So they could actually make that mistake. You could make a good argument for that, As to whether still this should be trademarked the way the word Gibson is, well, I'll leave that for you guys to decide, but the courts have more or less decided that Dean is in the wrong and shouldn't continue making these guitar shapes that they've made for 40 years. Anyway, leave me your thoughts down below, whether it's about the guitars or just trademark capture in general. What's really interesting, I think, too, thinking about Disney, is that Disney could potentially capture a trademark like Peter Pan or Cinderella, so that if you made a new Peter Pan movie, even though Peter Pan, the book, and therefore your derivative work, the adaptation of it, you can legally publish a derivative work without anyone's permission, right? Because it's in the public domain. Could you call it Peter Pan without risking a lawsuit from Disney who says, no, that's our character. That's trademark. Peter Pan is a trademark of the Disney Corporation. And to what degree could you make a Peter Pan movie? Could you make Peter Pan and have him look the same, or does he have to look completely different? Like, what are you going for there, right? So it's an interesting idea that something from the public domain can actually be captured, like it can be captured by something by Disney, just by making a strong trade association, a strong brand association with whatever that trademark idea happens to be. So leave me your thoughts down below, and I'll see you all next time. Have a great day.